remedies. When we're trying to find a solution to a problem, we end up calling that solution a remedy. And a remedy could take different forms. It could be an accommodation. It could be some methodology where you sit down there and pay attention to the problem that's there and you make an accommodation with it. It could be a Title IX case. It could be a matter of there was some conflict over some of the issues in Title VII. So you have an ADA claim, American Disability Act claim. So you want to find some kind of accommodation to a workplace conflict. We had a part-time counselor that worked at another college that was not IVC, and I could actually see her occasionally where she would pull into the parking lot and she would open her door. She would have to reach up and pull down on a strap on an overhead container, and a wheelchair would gradually come down on its own, and she would struggle to get into the wheelchair on a daily basis. Quite frankly, it was quite a remarkable feat that she actually continued to work with her disability, but thank goodness that she did in the aspect of where she was a quadriplegic. She didn't have full use of her arms or her hands, so she would get into her wheelchair, she would struggle up a slight incline on a sidewalk, and she would get into her office. Well, unbeknownst to human resources, the college that was there was not paying attention to her, and she was a part-time faculty member. She would go into her office as a part-time counselor, and she had a wheelchair, and she had a wheelchair with wheels on it, and the wheelchair had 27.5 inches, which is your pretty much standard width of a wheelchair, and the distance between the edge of her desk and the edge of the door was 29 inches. That gave her crippled hands that she could really not straighten the fingers out 1.5 inches, and almost inevitably on a daily basis she would bump her knuckles up against her desk or her door, and frankly, I don't know about you, sometimes words escape my mouth when those things kind of happen, but she was in this situation on a regular basis. Nothing was done by the college to sit down and accommodate her needs. There was no, by the time she showed up at work, all the handicapped parking stalls were all taken up. And you ever notice that sometimes handicapped stalls, they have somebody that pulls into them, they got all the appropriate placard, and they get out and they run to the door, and you kind of wonder, oh wow, I could see they really are disabled. And you think this in your head, but you don't say it out loud. In this case, here she was, just about as disabled as she could possibly be, but she still sought to sit down and be employed by the district. Pretty impressive feat, far as I was concerned. A bit of courage there, to say the least, and certainly a lot of determination. The college didn't make any accommodations. I stepped in and required accommodations. I required them to sit down and change the doorway when they complained about there's 2 desks on it. I said, find another way. You need to deal with this. In the meantime, she filed a claim. Okay, she filed a claim with the Equal Employment Opportunity Commission over an ADA claim, and all of a sudden we had an investigator coming out. In the meantime, she was furious because she'd been treated so poorly by the college. By the time it was all done, we made the appropriate accommodation in her office. I designated a parking space for her. I said, I don't really care what your issue is at the college. You will do this. If you don't do this, then we'll take formal action as a district. And so the college complied finally. But that said, we had to make an accommodation for her. Now, just so you know, and I want you to pay attention to this concept, by the time it was all done with that organization, they passed it on to somebody else, and they found out other claims, and all of a sudden we had 2 or 3 different investigators coming out on different claims within the college that weren't even filed. They were set down there. One investigator found another one and turned it over to another and another. By the time it was done, it cost that college $275,000 because they found one handicap ramp that was a 7-degree pitch, and the 2011 Title VII claim, the 2011 sector had not been complied with, and it's supposed to be a 5-degree pitch. They had to tear up the sidewalk, put a brand new one, and by the time it was all done, it was pretty extensive and pretty expensive. It cost the college a lot of credibility. It cost them an awful lot of money because of the fact that they didn't pay attention to just one person. And quite frankly, I'm not quite certain how you go about ignoring that when somebody struggles like that. And that's part of the aspect of human resources. Every once in a while, you should treat people like they're human and have some type of accommodation. but sometimes you have to do that. Retaliation, the employee could have claimed discrimination, but because our human resource department stepped in, we sat down there, we did all we can to accommodate that person appropriately in spite of the college, and we pursued that by the time it was all done. So the retaliation, it wasn't excused except for the fact that here we sat down, we fixed the problem, we made an accommodation to the problem, except for the fact that another inspector from another department came over and found another problem at the same college, and that's kind of the price you pay sometimes when you just don't sit down and pay attention. The Civil Rights Act, by the time it was all done, sometimes there's a lot of volume to it. You'll have administrative remedies out there. All claims, as soon as you go through an EEOC process, okay, you want to sit down and comply with them because they do have the capacity to file a lawsuit. The other capacity they have, if they don't find anything at all, they issue a thing called a right to sue letter. Make certain that's in your notes. Okay, a right to sue letter means they didn't find anything, but that doesn't preclude the person that's complaining to go out on their own and file a claim with the court. The EEOC is an administrative remedy. The courts often will say, have you exhausted your administrative remedy over here with the Equal Employment Opportunity Commission? If the answer is no, the court may say, don't waste our time, go back and do that, let the investigator do that, because that'll save the court time in the aspect of reviewing the case, having a government inspector out there. So sometimes they'll have an administrative remedy, even though technically administrative remedy would be the company itself. Now that said, okay, once the investigator finds, they explore the complaint, if they don't find any violations of law, they issue a right to sue letter. That doesn't mean the person's going to sue you. It means the person now has a right to sue because the employer has been cleared by the EEOC without any notice of violations. Now, if there is a violation, the EEOC may turn around and come to different aspects as to how you're going to do that. Some of the remedies that they're going to look for to say, well, you need to fix this. Well, what does that mean? Well, this problem's been existing for this many years. You need to get them back pay, or you need to pay them up front. You need to sit down there and pay money to fix this accommodation to take care of them. It might be you have to reinstate an employee that you dismissed inappropriately. It might be seniority, giving them seniority retroactively, also seniority currently. You might have to give them some injunctive relief. It could be compensatory damages, punitive damages. You may have to pay the attorney's fees. There's several different ways that either you can sit down and negotiate with the EEOC, okay, or you can sit down and deal with it and let the courts tell you how to go about doing that. Back pay, money awarded for time the employee was not working because of the discrimination. Front pay, some type of an award to the claimant for reinstatement if it's not possible or feasible. Retroactive seniority, here are key terms you need to know because these are all remedies that are frequently used by the Equal Employment Opportunity Commissions. Make whole. Okay, make certain the position that they're in, that you are going to sit down there, restore to the employee as if the event never happened. We call that making that person whole. And recall compensatory damage, that's to sit down and compensate them for the time off. So the money damages where they would loss of wages from whatever injury, whether it's a physical injury or, in this case, more likely a discriminatory injury. And then punitive damages, money over and above the compensatory damages. So you want to look at all that, the different aspects of it. You'll have different caps that are out there. Here's a listing of the caps. It's not my expectation that you memorize it for the purpose of this class, but I do want you to know that there can be compensatory and punitive damage caps that are out there for depending upon the size of the organization. If you have less than 15 employees, a lot of this doesn't apply to you. So that being said, let's take a look on where you can find resources for all this. Law libraries, just about every private law firm will have that. Okay, so you'll see some also in courthouses, depending upon where you live. The internet has a ton of different resources available to you. Quite frankly, if you are working full-time in human resources, you need to have a couple subscriptions to different law things to look it up, even if you are not an attorney. Some of this stuff is not needed for an attorney if you have good common sense and know how to read well and interpret and create an environment that really does comply with the law. And you can always sit there and make an adjustment if you ever have an investigation. Some of the tips. Okay, make certain you always have the best person for the job. Avoid expensive mistakes, especially in the area of prohibition. Be transparent. Have safe communication about the concerns. Have training with your staff. Document any kind of HR system that you're using. You want to sit down and be able to sit in front of a chair, in front of a jury, and say, this is what we did. Yes, this might have happened from that person's perspective, but this person here has had all this training over here. We've done this, and this is. You need to sit down and act every time you do something for employment law, just like you're in front of a jury explaining what you've done, and that whatever you say or do could be published on the front page of your local paper, because sometimes it is. Okay, so retaliation with filing a complaint, it's a separate offense. Avoid even its appearance if you possibly can. Don't do it, don't do it, don't do it. Okay, so review termination decisions internally. I want you to be listening at this point. You're going to get the academic and also the practical. If you ever go through a disciplinary action in your office and you're working on behalf of your employer, you always have a personal witness that sits in your office and take notes. Their job is to keep their mouth shut and to write about all the activities that are in there. If you are dealing with an employee personally, you want to make certain that you have a witness to sit down and take notes to make certain that everything you say is either on notes or they have a witness to refer to, because there have been situations where I've been in that case and I've had the employee there and their union rep and they lied about what was said in the meeting. You need to always make certain you are protected if you are the one in charge of enforcing employment law. The other part too, you want to make certain that nobody can sit down there and say whatever words may be claimed or whatever, that you will have some type of aspect, but it also might help keep you from getting your emotions involved in the dialogue. The other part too is sometimes supervisors are not trustworthy. I have had a supervisor going through, and I brought in the employee, I brought in the supervisor, and I heard the stories of both of them together and individually, and the employee had far more credibility in about 5 cases over a 10-year period where the supervisor was not credible, and I had to sit down there, reverse the supervisor's decision, and eventually 2 of those 5 supervisors were terminated because they continued to make bad decisions. Pay attention. You are a third party. If you're the one in charge of employment law, pay attention. Keep your emotions out of the enforcement. Look on what's going on. Do your best to comply with all aspects of the law. Review all termination decisions, because remember, 67% of all lawsuits between the employee and the employer come from the way they were released by the employer. Not that they were released, but it was how they were treated out the door. Layoffs. If you're going to lay somebody off, I know that we live in a different world where people sit down and they think they can just sit down there and destroy somebody's life with a stupid text or email because they don't have a heart or a brain in them. If you're going to lay somebody off, especially one who's never done a bad thing for your company and just did good things, I think it is always the best thing to do it personally, heartfelt, give them a nice memo, give them support, and do it personally, face to face. Be careful on that. Make sure you document it, prepare, communicate, show empathy. It will save you a lawsuit or 2 in the process. Train employees to understand the policies, train them to understand their rights, have them talk about really the aspect of reasonable accommodation, and make sure they know all about the different aspects of it. This section, know about administrative remedies, know also a right to sue letter. Don't panic when you see one, because of the fact what that means is that the administrative agency, the EEOC or whoever may be in charge, they have not found anything wrong, and they says, hey, if you want to go ahead, take a shot, go ahead and sue them if you want to. Invariably, they don't, because now you have administrative agencies saying they didn't find anything wrong. So that's actually a good thing, big picture wise. It doesn't change the fact if you're the one receiving it, it makes you a bit nervous in the process. Remedies, make certain that you, if you can, work with an agency, but more importantly, work with the employee. If they have an issue, address the issue. Take care.